SJC-12213, Commonwealth v. Timothy O. Dayton.
May it please the court.
Good morning,
Good morning, Your
Mr.
Honors.
Smith. It appears as if no one seems to want to hear your argument except for us. But we do. We do.
The panel is the important party. Thank you, Your Honor. May it please the court. Good morning, Your Honors. My name is Ryan Smith, and I represent the appellant Timothy Dayton. Your Honors, this case is before the court on a question reported by a justice of the Berkshire Superior Court, and that question is whether a defendant with 2 prior convictions for operating under the influence, who's been arrested and charged with operating under the influence, 3rd offense, may be held without the right to bail under Chapter 276, Section 58A. This court should answer no to the reported question and hold that the language of the statute applies, that Section 58A is triggered for the crime of OUI only when a person is charged with having 3 prior convictions. And therefore, in this instance, the statute would apply upon a 4th offense. And as a brief roadmap for this argument, first, this is because the plain language unambiguously uses the word conviction, which is a legal term of art that is cemented into the provision by the surrounding words and grammar in the provision. If the legislature had wanted to apply the statute to a 3rd offense, it would have said so.
If it's so clear, and believe me, I understand your argument, which is very well taken, that the language in Commonwealth versus Dodge and Commonwealth versus Young is dicta. But if it's so clear, the SJC got it wrong twice, and trial court judges have been getting it wrong for 22 years. So it can't be that clear.
Your Honor, with respect to the Dodge and the Young decisions, this issue obviously was not raised by the parties, it was not briefed, and it was not argued before this court.
And I totally agree, and it's a very important point. I agree. But I'm just saying, if this is as clear as can be, we've got the SJC getting it wrong twice and trial court judges getting it wrong for 22 years. It can't be that clear. Maybe the rule of lenity helps you out, but I don't know how it could be clear if that's the case.
Why wouldn't, this sort of goes to that point, but since in the next clause it uses the word convicted of, find it again, or convicted of a violent crime as defined in Chapter 121, right?
Yes.
That's the beginning of that clause. The beginning of your clause is arrested and charged with a violation. I mean, why wouldn't it have begun or convicted of a 3rd offense and arrested and charged with a subsequent offense? I mean, it just doesn't make sense why it would begin with arrested and charged, particularly when you look at Chapter 90, Section 24, and it says on a 3rd conviction, this happens, on a 4th, blah, 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 blah. So at the very least, it seems to me it isn't so clear.
I can answer that question. So our clause says arrested and charged with a 3rd or subsequent conviction. And so if you actually look at the underlying statutes, if you look at the OUI statute and then you look at the statute that relates to that following clause, which is regarding 269 Section 10, which is the weapons statute, the structure of the statute is written differently. And that in the OUI statute, it's expressly referring to the number of prior dispositions, at least in that OUI statute, number of prior convictions. So it says that defendant who has been previously convicted by a court of the Commonwealth, the underlying weapons statute uses different language. So it specifically says, whoever commits a like offense shall be punished. And then for a 3rd such offense shall be punished. For a 4th such offense. So the actual structure of how the statute refers to subsequent offenses is different. And the OUI statute refers specifically to really the number of prior dispositions. It doesn't actually say for a 2nd offense, for a 3rd offense. And so I think that explains why the Section 58A is, in a sense, uses that format in describing the subsequent offenses.
Does the rule of lenity apply to the issue of dangerousness?
Yes, Your Honor. The rule of lenity has applied to statutes that involve other deprivations of liberty, specifically the statute used to classify sex offenders under the Sex Offender Registration Board, and so where the effect would result in the deprivation of liberty, this court has applied the rule of lenity to other statutes that are criminal in nature. Yes, Your Honor.
So is the essence of your argument essentially is that the legislature essentially said if you're charged with OUI third? I mean, is that sort of how you're interpreting it? And OUI third's understood to mean OUI,
No, he says
With a
OUI
third
fourth.
conviction?
He wants OUI
no,
fourth.
but the indictment would say,
The
the indictment would
here,
say OUI with 3 prior convictions.
yes, Your Honor.
And is that referred to in the slang as an OUI, as a charge of OUI third, or was that charged
OUI
as?
fourth would be two things, the crime of OUI, and then while having 3 prior convictions. So that would amount to OUI fourth. And the statutory scheme really lays that out in Section 24 of Chapter 90. And so, in fact, that's another important issue, is that the notice to the defendant here, the defendant is actually charged in the instrument with 2 things, the crime of OUI and then a certain number of prior convictions. And that's really what we have here in Section 58A, is that it's charging the person, it's a predicate offense to be charged with having those convictions. And so the language is very much parallel in that respect.
Could you make sense, though, of the language that says or subsequent, third or subsequent conviction, if you're talking about an OUI fourth?
Certainly. A third or subsequent conviction.
It's the or subsequent that I just wonder if that really supports your interpretation of the statute. Arrested or charged with a third or subsequent conviction.
Certainly. If a person is charged with having 4 prior convictions, then this Section 58A would apply as to that individual. And so a third or subsequent conviction that the person is charged with would mean that Section 58A would be applicable to that individual.
But arrested and charged precedes both listed enumerated offenses here. The Commonwealth may move for an order of pretrial detention where a defendant is arrested and charged with a violation of 13B of Chapter 268 or a third and subsequent conviction for a violation of 24 of Chapter 90. So
Certainly.
arrest and charged precedes the OUI as well.
Absolutely. And the person is, when a person is charged with an OUI fourth, that person has been charged with having 3 prior convictions. The person would be right in the indictment itself.
I guess I'm having trouble.
Yes.
Are you saying that it's not, can somebody be arrested and charged with a third or subsequent conviction? Or are you saying they can't be arrested and charged with that?
No, a party.
I'm not saying that just because, I'm very confused about why arrested and charged would not just be arrested and charged as opposed to having already had a conviction for the third or subsequent.
Well, a party would be arrested for OUI, and then they're charged in the indictment with having prior convictions when they're charged with that subsequent offense.
Right, but you're allowed to, or there can be a hearing as to whether or not bail is appropriate when someone is arrested and charged with it, not when they've already been convicted of it.
Well, when you're charged with, again, with the 4th offense OUI, you're charged with those underlying convictions.
But if you're charged with a third,
Yes.
why doesn't that come under the language of the statute? I don't understand that.
If you're charged with a 3rd offense, you're charged with having 2 prior convictions.
Right, but it doesn't say here that you have to have 3 prior convictions.
It says that you've been charged with a 3rd or subsequent conviction, which means
Been
that,
charged with.
Well,
Correct.
that's what the Commonwealth says, because he was charged with OUI 3, right?
no, the statute specifically uses the word conviction, Your Honor. So
But in this case, he was charged with a third offense, is that right?
charged with a 3rd offense, but he was charged with having a 2nd conviction in the indictment.
It's the problem that the clause starts arrested and charged, and then it lapses into conviction. And to be clear, if the legislature took the editor's pen out and took conviction out of it, they'd be right. But they have the word conviction, so they got a problem.
I would agree with that, but also it's not just the word conviction, because there's a prepositional phrase that then modifies what we're speaking of about the conviction. So it's conviction for A, And so it's not just the word conviction, it's grammatically cemented into the clause. And so, you know, it wasn't just an oversight where they just included the term of art conviction. It's actually grammatically linked into the clause, which then says for a violation of
Right, so
section
if you
24
had
of chapter
taken out
90.
for a third or subsequent violation of,
Yep.
that would make it clear, but what they're stuck with is conviction for a.
Correct.
Doesn't this whole conversation show that this is ambiguous, that it's,
I would agree that this is certainly not a model of clarity. However, this interpretation is the only interpretation that doesn't require cutting significant parts of the statute right out of the statute.
Do you have any legislative history?
I contacted the social law library through a librarian and did some research, and I was not able to find any. I wasn't able to do an exhaustive researching of the background, but I was not able to find anything that's specifically related to OUI. I do know, as far as the history of this statute, that it was passed in response to ME versus Commonwealth, which this law was created to be one of those carefully limited exceptions to pretrial freedom permitted by the Due Process Clause, and that this language itself is language of limitation. And so I think that's an important lens to view this statute through, Your Honor.
I think the Commonwealth says this, and you agree, that OUI third offense is the first of the staircase that is a felony?
It is the first that's a felony. I think it's important to note that, of course, a person only can receive a state prison sentence after they're convicted, after trial, after the procedural protections. The policy decision that I believe underlies the legislative distinction between third and fourth here is that for an OUI fourth, it's actually 4 times the sentence required for OUI third, and also the policy here seems to be that we want to punish people clearly that are dangerous, people that are incorrigible, people that pose a public safety risk. Somebody who has already served a minimum mandatory of 6 months and then goes out and is arrested for drinking and driving clearly has a markedly greater degree of dangerousness than a person who is arrested and charged after a probationary sentence.
Well, what do you say about, do you win the battle and lose the war on the residual clause?
No, Your Honor. I believe that certainly one canon of statutory interpretation is that words and phrases should not be deemed to be superfluous. And in this case, if the residual clause would encompass OUI third, it would nullify the language of limitation that was placed in here by the legislature requiring conviction. And again, this is a carefully crafted, limited exception to pretrial freedom. And it was designed to be as such, and so it would essentially eliminate the language of limitation that's in the statute. And so I don't believe that's what the legislature intended.
So essentially, your reading of it is that it is a crime of OUI with an element, a required element, of the Commonwealth must prove that he has 3 or more convictions.
Actually, Your Honor, I believe that it's a sentencing enhancement that's charged within the indictment. So it's not that it's an element, clearly not an element under the case law, but it is a charged sentencing enhancement.
The charge with the sentencing enhancement of which but the Commonwealth would have to prove 3 prior convictions for that sentencing enhancement to kick in.
That's correct, Your Honor. Absolutely. And again, I believe it's consistent with, legislative finding to punish those who have served 6 months and then are again out drinking and driving, as opposed to somebody who previously received a probationary sentence. Significant deprivation of liberty. A person has held in custody without the right to bail for a period of 120 days. Your Honors. And I would also point to the court, Commonwealth versus LeBlanc, which stands for the proposition not only that the court will correct dictum from prior cases, but also that it's a job of the court to apply the statutory language, not to amend it. And this was stated by the court as recently as October of this past year, and I think it's an important proposition here, where the legislature included a term of art, the word conviction, within the statute, and the Commonwealth's interpretation would jettison this legal term of art and say that a person could be held upon simply being arrested and charged, require the court to perform surgery on the statute, Your Honors. And so, based on that, I would ask that the court answer no to the reported question. Thank you.
Thank you.
Chief, just one more thing, if you don't. I still don't understand how you get around the residual clause, which applies to any felony that by its nature could create dangerousness. How do you get around that phrase if you're right on the other phrase?
Your Honor, again, the law, I believe, was crafted not to include all felonies. It was clearly intended only to include felonies that have an element of the offense, particular things, crimes of violence, and certain offenses. It doesn't include all felonies. And where the legislature specifically addressed the crime of OUI and included in the statute language of limitation, limiting the applicability of Section 58A to OUI only in certain circumstances, I don't believe the legislature then intended to create another provision that would essentially nullify that specific language of limitation. And so the specific would control over the general in this case, Your Honor.
Okay, thank you.
Thank you very much.
Morning, and may it please the court, Joseph Colliflores for the Commonwealth, Assistant District Attorney for the Berkshire District. It is clear when looking at the language of Section 58A that the legislative intent was to hold a defendant who has 2 prior convictions and is arrested and charged with a 3rd offense as a danger to the community. And this has been addressed both in Dodge and Young. And the Commonwealth would proceed with that it's a specific offense within the statute, as well in the arguendo that it does fit within the residual clause.
But what do you say to the argument that is made that since the legislature used the word, didn't use a 3rd or subsequent violation, but conviction, that it has to be the 4th violation, and you need to, because you need to have in place the 3rd conviction?
Yeah, I'd refer back to typical norms of statutory construction where we look at the intent of the legislature, looking at the words, the whole phrase, the whole statute as a whole, given the intent of the legislature. And when
How do you know what the intent of the legislature is?
Excuse me?
How do you know what the intent of the legislature is except through the language of the statute?
I was unable to find anything that specifically states what the intended purpose.
So he says it's intended to do one thing, and you say it's intended to do another, and I don't understand how we're going to get there other than through the language itself.
And another part of that is construing similar statutes as well. And I think that when you put Section 58A in correlation with Chapter 90, Section 24, there's a clear legislative intent to start holding defendants charged with a 3rd offense of OUI for their actions. You look at OUI 3 in Chapter 90, that is the first time where there's a felony sentence available up to 5 years in the state prison. And the same effect in Section 58A.
What's the sentence for OUI 2nd?
OUI 2nd.
Isn't
Refer to my brief for a moment.
there some mandatory incarceration?
I believe it's house time 2 to 2.5.
But isn't there a mandatory period? No?
I believe there is a small mandatory house period.
Unless the OUI first was more than 10 years ago.
Correct.
So are we supposed to conduct surgery on this statute and take the word conviction and the words 4A out of it?
I don't think it necessarily requires excising it, just understanding the.
You want us to ignore it then?
Excuse me?
You want us to ignore those words?
No, you look at those words with the whole clause in effect. When looking at the whole clause, it's arrested and charged with Section 3 offense or a 3rd or subsequent conviction for a violation of Section 24. Violation of Section 24, it doesn't specifically say 1A1 for OUI offense, and presumably it also includes the remaining offenses within Section 24, including negligent and reckless operation. So looking at that clause, arrested and charged, it's clearly the legislature included arrested and charged. It is not meant to come in at another point, such as if, as the defendant contends, a 4th conviction. If it was to be a 4th conviction, the word 4th would plainly arise within the statute itself.
Or if they took out the word conviction, it would just say arrested and charged with a violation third, right?
Yes. And
So do you agree it's ambiguous?
I do not think it rises to the level of completely being ambiguous that the rule of lenity applies to Section 58A. It is clear, at least from the Commonwealth's perspective, that what the legislature intended is that OUI 3 triggers a dangerousness to that defendant, to the community.
Judge Agostini thought it was ambiguous, right? That's why he reported it?
Yes, he did. No. As far as I can infer from him reporting the question. Yes.
Well, he decided the other way to begin with.
Yeah,
Yes, he did initially refuse to hold a dangerousness hearing. We did appeal that decision, citing Commonwealth v. Dodge and Commonwealth v. Young, both 1999 and 2009, respectively. And the judge did hold a dangerousness hearing, which the Commonwealth set forth 3 police reports outlining why this particular defendant is indeed a danger to the community. And I've outlined those facts within our brief, and I'd like the court to pay specific attention to the last one of September 11, 2015, where
but we don't get there respectfully if we think that the statute does not apply, correct?
well, there is the argument that if it is not a offense specifically within the statute, that it does fall within the residual clause of both being a felony in which there is a substantial risk of harm to another. And I would argue that even if it wasn't a specific clause within the statute, this specific case, which was indicted as an OUI 3rd offense with the possibility of 5 years in the state prison, the specific facts here show that this defendant was a menace to society.
But that's not in the report of Judge Agostini, the question of whether it is within the residual clause?
It is not within the explicit question reported, no.
I'm sorry, the residual clause you're referring to involves a substantial risk that physical force against the person of another may result?
Yes. It's
And so drunk driving involves a substantial risk that physical force against the person of another may result because you may crash into their car?
Well, more specifically, operating under the influence has been called by the appeals court a deadless menace to anyone that is on the roadways, both including civilians and police officers and emergency personnel that are responding to the scene of an accident. Now, the September 11th accident here, the defendant was in a single motor vehicle accident. Clearly, he did not run into any other vehicle, but he then proceeded to try and reverse away from somebody that responded, as well as rev his engine at a police officer that was attempting to wave him down both with his flashlight while he was outside of his police cruiser, which had his emergency lights on.
So it's your argument that the first OUI can be the basis for a dangerousness hearing because OUI poses a substantial risk of physical force against the person of another?
The court would be then ignoring the requirement that there be a felony offense. It's a requirement that there be a felony offense with a risk of substantial force.
Okay, so
and
you're
that is
saying
only
that-
triggered upon OUI 3 with a 5-year potential maximum, and then with
And so if
potential
that
force
was
against.
understood by the legislature, why did they bother to make a specific provision regarding OUI 3 or 4?
Well, that's why that's a secondary alternative argument. My first argument that it is one of the predicate offenses within the statute. But if you are to assume that it is not because of the ambiguousness of the language, then yes, it would fall into the residual clause. As to why the legislature left the possibility of 2 different OUI positions, I cannot speak to their intent. It's not clear from that language. But I would propose it leaves open the possibility that when there are severe and grave instances of operating under the influence for a 3rd offense, that it gives the Commonwealth the opportunity to secure their neighborhoods from a drunk driver driving through it. To read the statute as arrested and charged with a 3rd or subsequent conviction to take into effect only after a conviction, then it ignores the legislative intent that the OUI statute, Chapter 90, when they gave OUI 3 a potential 5-year maximum, to say, oh no, they're suddenly, worthy of a 5-year sentence in a state prison, but at the same time, they're not that dangerous that we can't hold them pending that trial. That would be an absurd result. The fact that they're dangerous enough to warrant state house time, but not enough to remove them for 120 days leading up to that 5-year house time, state prison time.
Can you just help me make sense of language that says you're arrested and charged with a conviction?
Sure. So arrested and charged applies to both parts, both predicate
No, I
offenses.
understand that, but I understand how you can be arrested and charged with a violation. I don't understand how you can be arrested and charged with a conviction.
Sure, but the conviction word does seem a little out of place, but my argument there would be that arrested and charged with a third conviction. We're arresting and charging you, saying that you will have a third conviction.
Will have a third conviction.
But isn't your argument that it is that unusual language because Section 24, after it defines the crime, goes on to say for a third conviction, for a second conviction, this happens, for a third conviction, this happens, for a fourth. So it uses the word conviction as part of the whole. That's what if you are convicted of that crime the third time, this is what's going to happen to you.
That is correct, Your Honor. Section 24 does use that language when setting out the sentences for each step on the ladder of OUIs. And I think that language is resembled here with the conviction portion.
And you would concede that the word conviction is a final adjudication of guilt, correct?
As a definition of the word conviction, yes, I would.
Right, and someone charged has not been adjudicated guilty, correct?
That is correct. And if you look at the language here, if we take Section 24 as the subsequent conviction portion, those are sentencing enhancements, meaning that you can get greater amount of time served as the number of offenses you create. Here, the legislature in Section 58 is recognizing that and uses the same language, conviction. So it could potentially be construed that you are being arrested and charged with an OUI offense having that sentencing enhancement. Now, it's mirroring the language and it's mirroring the step as well, and it greatly reflects the fact that OUI 3 is a felony with great harm.
Well, if the legislature ups the ante after a third conviction, why shouldn't we interpret this particular section to say that 58A is only going to apply after there's a third conviction?
Because, Your Honor, it doesn't say fourth offense. Reading Section 58A, it says third conviction. So he's arrested and charged. If I follow Justice Gaziano, my interpretation there, it's the arrested and charged with a sentencing enhancement, which then reflects it. To hold that a person as a danger would ignore that word three with a third and insert fourth. And I think that would violate many of the norms of our statutory construction that we've used throughout the years. And if there's a follow-up question, I was going to turn to Dodge and Young and dicta, but
Go ahead.
the Commonwealth did look at this in Commonwealth v. Dodge and Commonwealth v. Young in 1999 and in 2009. And the statute was created in 1994 and has been amended numerous times. The legislature is assumed to know what judicial constraints has been put on a statute. And here in Dodge and Young, albeit in dicta, has interpreted it. And not only has the SJC interpreted, but the chief of the trial court has also taken that same interpretation and forwarded that on to the trial court judges.
That's because, we can just be wrong in the dictum, and that would explain it, right? Why the chief of the trial judge, chief justice of the district court did what she did.
Certainly that has been the power of the SJC to clarify prior case law coming out, especially one that's been around since 1999 and 2009. The legislature, being assumed to know what this is, clearly left it in there. 1994, 5 years, then the Dodge case came out, and then I believe there were amendments in both 2000 and 2010. Now, the defense counsel cited Commonwealth v. LeBlanc and kind of fixing what prior dicta errantly has been. And I believe Chief Justice Gantz urged the legislature to fix ambiguous language. And I would argue that LeBlanc is completely inapposite as far as the facts presented in LeBlanc, in that there was an additional item inserted into the statute by the dicta. Here, we do not have that. We have a plain interpretation of the statute saying that it is upon arrest and charge of an OUI third offense. If there are no further questions, I would rest on my brief.
Okay, thank you.